number 104, the people of the state of New York versus Sixtus Udeke. Get it out. Thank you, sir. Good afternoon, counsel.
Good afternoon, and may it please the court. I'm Benjamin Weiner from the Center for Appellate Litigation on behalf of Mr. Udeke. I'd like to please reserve 2 minutes of my time for rebuttal.
2 minutes? Yes, sir. Isn't this case very different than Suazo procedurally? Suazo was charged with the B misdemeanor. Defendant here is charged in the top count A misdemeanor.
I'm not sure why that's a relevant distinction here, Your Honor. The bottom line here is that the court effectively told Mr. Udeke that he would have no right to a jury trial on...
But did she actually say that, or did she say it depends on how the prosecution chooses to proceed, which seems to me an entirely accurate statement. Are they going to continue to try to join these all together? Are they actually going to reduce? I don't even see what the error is in what she said.
Well, Your Honor, they're talking about the contempt charge here. That's the charge that Mr. Udeke is pleading guilty to. And defense counsel, this is after Mr. Udeke asks about the right to a jury trial specifically. Defense counsel says it was represented to him that this would be reduced to a B misdemeanor.
But getting back to the Chief Judge's question, that had to do with a plea. Okay, this case has to do with a plea and whether that plea was knowing involuntary because of what the court said. At the time that the court was giving instructions or having a colloquy, the charge was a Class A misdemeanor. Mr. Udeke was entitled to a jury whether he was subject to deportation or not subject to deportation. So I see this as a very different context than what Suazo was.
But the Constitution requires that Mr. Udeke understand the rights he's waiving by pleading guilty to the charge that he's pleading guilty to.
How could he not when the court said it depends on what the prosecution does? Isn't that an accurate statement? If the prosecution decided, okay, you don't want to plead to this, then we're going to go ahead and we're going to proceed with a trial on the Class A because now you're arguing you're entitled to a jury on the Class B, okay? Or it could have done something different. And that's exactly what the court said.
It was not an accurate statement, Your Honor.
But what if it was just a Class B misdemeanor now and he was subject to deportation and the court, when they're allocuting, says you have the right to a jury, you're waiving that right, we go through the whole thing, and now you come here and you say he didn't have a right to a jury. How is it a knowing waiver?
Well, that's a very different scenario, Your Honor, because in that scenario, the defendant is waiving more
Here he
than
knew that he
has.
was in some context waiving the right to a jury.
But
Right.
he was led to believe by the court that he would have no right to a jury trial on the B misdemeanor to which he pleaded guilty. That's exactly what the court is saying when it says it depends on how the prosecution proceeds. It's saying if the prosecution does just what counsel has said they are saying they will do, you will have no right to a jury trial. And that wasn't true in light of Suazo because Mr. Udeke...
Did the trial court know that at the time?
Well, this plea was taken before Suazo was decided, but respondent doesn't
No, but
contest
did they know that he was subject to deportation? I mean, I thought in the forms that were filled out at the time of the plea, that's unidentified for probably good reason, but does the court then have, because they're in a kind of a strange area here, so does the court have an obligation at this point where nobody's raised that? So depending on what you do you have a right to a jury or not? So isn't it kind of accurate? You know, maybe.
Well, I'd make 2 points, Your Honor. First of all, the rap sheet says that Mr. Udeke is a Nigerian citizen.
But it doesn't say he's not a U.S. citizen. You can have dual citizenship.
It doesn't say he's a United States citizen.
Right.
There's nothing in the record to indicate that he's a dual citizen. The record pretty firmly establishes that he's a Nigerian citizen, and respondent conceded that before the appellate term.
There would be no reason to hide one's U.S. citizenship.
No, Your Honor. No, there wouldn't.
But didn't we say in Suazo that the defendant really had a burden of showing not only citizenship, but the effect of, the immigration consequences of that.
If the defendant is actually going to trial, he has that burden, but this court has always been clear that it is fundamentally the court's responsibility to tell the defendant which rights he's waiving by pleading guilty, and not the other way
The court
around.
doesn't know at that point. I mean, the point of Swaza was you have to tell us, because it depends on your status. So if you're going to not make an issue of the status, and again, I can understand why, then how is the court supposed to know what your status is? And at that point, they didn't.
All the court needs to do is not get it wrong in the way that it was wrong here. The court can say, if you can establish before trial that you are an immigrant who will be subject to deportation, then you will be entitled to a jury trial.
Well,
That's akin-
doesn't the court only a few questions after this particular part of the colloquy go on to inform this defendant that there may very well be deportation or other adverse immigration consequences flowing from this particular plea?
Sure, but what the court never tells Mr. Udeke is that those consequences would entitle him to a jury trial.
Well, my point of that is the court obviously is alert to this issue with the defendant, otherwise there would be no point to that.
Oh, yes,
particular
yes,
reference.
by all means, Your Honor,
Told them
and
they have to
Well,
do that
that's
in CAD
Peke
too.
and others.
Yeah,
It seems
that-
to me that what you're arguing is that the court has to think about every possibility here that could take place, whether the people were going to just go ahead if he demanded a trial on the Class A misdemeanor, on the B misdemeanor that they offered that might or might not have deportation consequences, or maybe on a completely different B misdemeanor, or I don't know what other possibilities there are. But have we ever said that the court has to do that in a plea colloquy?
that's not what we're asking the court to do here, Your Honor.
But that's essentially, it seems to me, because what the record shows the court said is it depends on how the people choose to proceed.
And it did not depend on how the people chose to proceed.
Well, it
He
did,
had-
because it depended on whether they were going to reduce it to a B misdemeanor that did or didn't have immigration consequences, right?
What defense counsel has just said is either you're going to, there's the A misdemeanor. Unquestionably, he has the right to a jury trial with respect to that charge. The reduced attempted contempt charge, he also had a right to a jury trial under Suazo. And so in no way did it depend on whether the prosecution reduced the charge here.
People never said they were going to go ahead to a trial on that reduced B charge. They offered the reduced B charge only if he was going to plead to it.
And he had a right to a jury trial either way, no matter how the prosecution chose to proceed. It didn't depend on whether they reduced the charge or not, or what they actually would have done. And that was the mistake that the court made
Let me
here.
ask you this, because the court had a whole nother accusatory instrument in front of it. What if they decide, you know what, the person who was the protected person in the order is not going to come in, so we're not going to actually proceed with that accusatory instrument at all. We're going to proceed on this, the one that had to do with the entry into the subway.
Your Honor, the
Why
charge.
is the court statement incorrect? I mean, I'm still struggling with that.
Well, the charge at issue here, the charge that they're discussing is the contempt charge. It's the charge that Mr. Udeke is pleading guilty to. The context makes that entirely clear. And what the court is effectively saying to Mr. Udeke is that if you proceed on this B misdemeanor attempted contempt charge, you will have no right to a jury trial. And that was not correct under
So I see that
Suazo.
your red light's on. Let's say we reject your premise that the court affirmatively misadvised the defendant. Then what? Can you still prevail?
Well, Your Honor, I think the court can look at this charge and say it didn't adequately convey to Mr. Udeke that he had the right to a jury trial and that he was waiving that right. I think that is exactly what happened here. That's exactly what the court said, is you will not necessarily have the right to a jury trial, when Mr. Udeke did necessarily have the right to a jury trial here. And therefore, he cannot possibly have made a valid waiver of that right. And absent such a waiver, the plea was not valid. Thank you, Your Honor.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. John Croyce for Respondent the People. What the court said was entirely correct for a number of reasons, but I think first and foremost, my colleague here is overstating, I think, what this court said in Suazo. Suazo did not establish a completely inalienable right for any class of individuals to a jury trial. What Suazo said was, defendant has a burden. There's a presumption, of course, that a B misdemeanor is a petty offense, that it doesn't require a jury trial. Now, if a defendant who is both a non-citizen and who is facing a charge that they believe is deportable shows affirmatively to the trial court both of those things, then they can overcome that presumption. But this is not a blanket thing.
That can be established by the record, right? So if the record in front of you is that the person is a non-citizen, or there's nothing to suggest they are a U.S. citizen, and the nature of the crime is one that, under the federal definition, is of course the crime, the type of offense that makes it possible that they're subject to deportation. But let's get to the colloquy, shall we, please?
Absolutely.
Because that's where there's been a lot of questioning. I'm having difficulty with what I understood was the argument in your brief, given the colloquy in context. The judge's first line of question is regarding the right to a jury trial. That's the first Boykin right he starts, the judge starts out with, and says emphatically at least twice, you have a right to a jury.
That's right.
And only changes course after defense counsel says, well, it was represented to him that this would be reduced to a B misdemeanor. And it's at that point that the court retreats from its emphatic statement about having a right to a jury trial. So how is counsel incorrect with respect to his argument that the colloquy shows that the defendant has been, at a minimum, misinformed about whether or not he's got a right to a jury trial, given the ruling in Suazo?
Well, first of all, you're right, Your Honor, that this could be shown by defendant from the record, but it wasn't shown by defendant from the record.
But I'm on the colloquy now, so let's talk about that.
But, Your Honor, with respect, I think it informs the colloquy, because a showing under Suazo that established that right might very well change the colloquy. No showing, however, the statement by the court was correct on those terms. But, Your Honor, it was also correct on general terms. I read this colloquy as Judge Peterson attempting to capture every possible situation that defendant could be faced with. And the literal words, once alerted to the small amount of confusion that appeared to be going on there, the literal final words on the matter were, it could be a judge trial, could be a jury trial, depending on how the people chose to proceed.
But isn't the judge responding to the only thing that's presented in that moment?
The judge
to the B misdemeanor? Isn't that what the judge is responding to, not something else?
Well, yes, but I think this broad statement is the response to that. It is the attempt to clarify for the defendant that had this gone to trial, there were a couple of different ways that this could have gone.
Okay, what would that have been?
Well, Your Honor, we could have, as I think was brought up, we could have dropped the contempt charge. We could have gone forward on something like theft of services. We could have pulled the complaint. We could have issued a superseding information charging a non-deportable offense. There were certainly ways that we could have gone forward here that would not have implicated deportability at all, which goes back to the fact that the statement read literally is literally true and can't be a misstatement.
But the upshot of that argument, I think, is that then in your ordinary case where a felony is charged, a proper statement by the court would be, you might or might not have a right to a jury trial depending on how the prosecutor intends to proceed. And that would be sufficient to apprise defendants of their jury trial right.
Yes, Your Honor.
And that would be perfectly acceptable?
I believe so, Your Honor.
Okay.
Yes, I think certainly under circumstances that are similar to this one. I mean, obviously,
Well, I wasn't asking about that. I was asking about circumstances that are dissimilar from this one.
Dissimilar in which way? I'm sorry, Your Honor.
That there's no deportation consequence, no B misdemeanor issue. It's just I'm charged with murder, and I'm thinking of pleading to something, a lesser form of homicide, and the court says, I want you to understand, you might or might not have a jury trial right depending on how the prosecution decides to proceed, because they might charge you with trespass instead of homicide.
Under that circumstance, that's absolutely true, Your Honor. I don't suspect that a court would have gotten to that point
So in
unless
other
this
words-
issue was. Sorry, Your
So
Honor.
in other words, what the court is doing there is saying, I have no idea if you have this right. I have no idea.
I don't think so, Your Honor, because I believe a situation like that where that arose would be in response to this kind of question. That seems unlikely to be something that a court would sua sponte say. But when you're dealing with a situation, setting deportability aside, a situation where somebody is asking a one-step further into it question about what could have happened, that statement would be true, and it would be germane and responsive to what the defendant was concerned about. So, Your Honors, both because he didn't make his Suazo showing to overcome the presumption, and because the statement was literally true, we are in a Boykin case. And without an affirmative misstatement, without any sort of there were all three Boykin rights. There were more than that on the record. With everything else on the record, holistically, this is certainly a voluntary plea.
Along those lines, can I just ask you about your position on preservation?
Yes, Your Honor.
Here we have the plea and the sentencing in the same proceeding, and if this is really about the plea and the Boykin rights and not about Suazo, isn't it all on the face of the record? And therefore, why would this not be an exception to the preservation requirement?
Well, it would be all on the record if Your Honors adopt our position that this was a completely true statement.
That was my hypothetical.
In that situation, I suppose preservation wouldn't necessarily be an issue, but what we have here is defendant is asserting something is very specifically wrong with this colloquy, and then they paused the colloquy to address essentially what defendant was concerned about, and then they present defendant with another opportunity later on to speak on whatever subject he wants. Defense counsel had the same opportunity. They choose to address different legal matters.
Where
I think,
does
Your
the
Honor,
record establish all these pauses and breaks?
The record establishes, the first pause and break is during the Boykin colloquy itself, where the court says that he had the right to a trial by jury. Defendant pipes up and says by jury ? Then they pretty much pinpoint discuss this question, and then at the end, before a sentence is imposed, because that's the crucial part, defendant is given the opportunity to speak. He does indeed speak. He speaks about the underlying order of protection. Defense counsel also speaks. Now, Your Honors, that is the opportunity.
But this record looks like all those records where it's basically a joint plea and sentencing proceeding. You're moving directly from one to the other at the conclusion of the plea.
It is.
Where is the opportunity?
I think the opportunity here is unique because of the fact that this issue was flagged specifically. I think that really does change the tenor of the situation. They are talking about jury trial versus judge trial right. This was a perfect opportunity for defendant to, at minimum, ask for clarification, and he didn't do that.
He did. He said by jury, and the court says a jury trial. That's correct.
Sorry, Your Honor. A clarification on the argument the defendant is now raising. The Suazo, not sure the right adjective, but the Suazo-esque argument the defendant is now raising. It was an opportunity to make that claim, and he didn't make that claim. For that reason, I'd say it's unpreserved. Your Honors, if there are no further questions, thank you very much.
Thank you. Mr. Weiner?
Your Honors, Boykin imposed a duty on the court to ensure that the defendant makes a knowing waiver of his right to a jury trial, specifically when he's pleading guilty. This record here just establishes that the court didn't do that. It said that the right depended on how the prosecution proceeded, when it didn't. No matter how the prosecution proceeded, Mr. Udeke had the right to a jury trial. So straightforwardly here, he could not possibly have understood that.
What about the
from this
examples he gave
colloquy.
before? Because I asked him the same thing, and he said, well, these are all the ways that there would not have been the availability of a jury trial. Or did I misunderstand him?
Well, Your Honor, you have to look at this in context. They're talking about the contempt charge here. That's the charge that Mr. Udeke is pleading guilty to. That's the charge on page 16 of the colloquy. Just immediately before this, they say, you're understanding that you're pleading guilty to B misdemeanor attempted contempt. That's what they're talking about here. The court isn't just saying, as a general matter, the court is saying, if the prosecution does what counsel has just represented that they're going to do, you will not be entitled to a jury trial. And that was not correct. I think with respect to this—
I think the argument is that if you're not going to take this plea, there are many options that the people have. I think that's the argument. So why is he wrong about that?
But that's not what the court said, right? What defense counsel says is it's represented to him that this would be reduced to a B misdemeanor. Immediately after that, the court says a trial by a judge or a jury depending on how the people proceed. The court isn't just saying how the people proceed in general. The court's saying if they reduce the charge or if they don't, two potentially different things might happen.
And the reality is, I guess, as I'm listening to your argument, I think you're also suggesting that if counsel had not made this statement about the reduction, certainly the judge would have been working on the same premise that, of course, if you're not going to take this plea, the prosecutor may have many options available.
Sure, I think that
You didn't need the prosecutor to make this statement, I think, to address the defense counsel, excuse me, to make this statement, because if the argument from the people is, if you don't plea, then the people have lots of options available, and some don't include the right to a jury, that was true before defense counsel made this statement, and yet the court emphatically said you have a right to a jury trial at that point.
Yes, that's right, Your Honor. That's exactly.
So all I'm saying is that the court appears to be reacting only to what defense counsel has said.
Yes,
This general idea that the people can choose to perhaps have other paths that they're going to follow.
That's precisely
Don't
correct,
plead.
Your Honor.
Can you reasonably read this record to assume that the people were going to reduce this charge whether he was going to plead to it or not?
Yes, that's what defense counsel says. It was represented to him that this would be reduced to a B misdemeanor. The prosecutor doesn't stand up in that point and say, no,
So
no,
you
no,
don't,
we're
you
not
don't
going
read
to
that
do
as
that.
meaning for him to be able to plead to the B misdemeanor?
No, because
Okay.
it's in the context
Wait a
of him
minute,
asking about this jury
They have a motion to
trial. right?
consolidate that's pending in front of the court. How can you say that that's a reasonable reading of this record when not only are they they answer ready for trial, but they're seeking to add more charges to go, or basically put forward 3 A misdemeanors. It was 3 or 2, I don't remember. And as I think somebody pointed out earlier, you don't actually know. I mean, from the time you walk out of the AP part to over to the jury trial part and finally get a judge assigned, the people right before you start are going to substitute a prosecutor's information. You're not going to go forward on these instruments.
Well, I think anecdotally, Your Honor, this was a fairly common practice in New York County and the Bronx, at least at the time, was to reduce A misdemeanor contempt charges to B misdemeanor charges precisely to avoid a jury trial. That's why Suazo happened in the
I think
first
it was more
place.
common in the Bronx. I don't know about Manhattan.
But counsel, going back just for a minute, if I might, Chief Judge, to Judge Wilson's potential, kind of colloquy, why isn't this accurate then? Because depending on how they proceeded, maybe they would have filed a violation or something. So why isn't it accurate depending on how the people proceed? You might not get a jury. I mean, like with a murder trial, they might file a violation. Here they might file a violation.
Well, I just disagree with Respondent that in a murder trial, where the defendant is pleading guilty to murder, and the court
But I think
says,
that was Judge Wilson, in fairness, not here.
Well, I think what Respondent was saying was, in that case, all that the court needs to say is, you may or may not have a right to a jury
But
trial.
isn't that what they
depending on
said
how the
here? I mean, they could
prosecution
file a
proceeds.
violation here, and then you wouldn't have a right to a jury trial. That's how they proceed.
But Boykin requires more than that. It requires a knowing waiver of the right to a jury trial, a right that Mr. Udeke unquestionably had, and which the court implied he did not necessarily.
Does it matter that Suazo was decided 3 years after all of this?
No, it doesn't, Your Honor.
Why not?
Because Respondent doesn't even contest that Suazo is retroactive. It's based on a federal right.
I just want to follow up something you just said. So in the course of doing a Boykin allocution, the judge said, you're waiving your right to a trial, your right to say have the people prove your guilt beyond the reasonable doubt, your right to compel witnesses, and goes in like one sentence, lists a whole bunch of rights. If they don't say the word jury trial,
No,
I
Your
thought
Honor,
you
that's
just implicated
not our
that.
position. I think
Okay, I just wanna make sure, 'cause I thought you just said
Concheco
that.
controls that. You get to look to the totality of the circumstances to decide whether, when there's an omission like that, it's sufficient to undermine the court's confidence that a knowing waiver of the rights was made. But here, again, this colloquy shows that Mr. Udeke affirmatively was not making a knowing waiver of his jury trial right. This isn't like an omission. Thank you, Your Honors.
Thank you.